Welcome everyone to this evening's, or this afternoon still, public law book launch. I have the book here. As CEO at LAG, I'm really thrilled to introduce this. I think it's a really welcome addition to the LAG catalogue, and I think it's going to be a part of your toolkit for making change for those who need it most. So thank you, Adam, for doing this for us. And thank you, Ollie, for writing your chapter, because it's good to have new and diverse voices and writing for LAG, so I'm really pleased. And on the back here, it says that we hope that this public law where discrimination issues arise, such as, and then I'll read them, because really this is every kind of issue that we deal with, but asylum, benefits, children's rights, community care, education, housing, immigration, mental health, police, prison law, and trafficking. If you haven't got a book already, then buy one, because I think you absolutely need it. And when I was in practice, to have everything in one place would just be brilliant. So thank you both for writing this, and have a good session, and hope you all enjoy having the book and listening to what Adam and Ollie and Louise and Shushin have to say today. Thank you. Over to you, Adam.
Thanks very much, Sue. I'm really grateful for LAG for having published this book. They are an essential organisation for claimant lawyers and for claimants themselves. And it's been an absolute pleasure to work for them. I'm delighted to be speaking alongside three fantastic discrimination lawyers today. We're going to do 4 short talks, and we're going to aim to be about 15 minutes each and finish hopefully by 5 o'clock. After I give a brief explanation of the book and look at a few key issues in discrimination public law at the moment, then Louise Whitfield from Liberty is going to talk about why discrimination in public law matters and what you can do about it. Which reflects some brilliant work that Louise has been doing for several years, encouraging public lawyers to understand discrimination law. Then Ollie Percy from Garden Court, who wrote the chapter on retained EU law of the book, is going to speak about that issue. And then Shushin Liu from Dowsey Street, who's been involved in a number of important recent discrimination public law cases, is going to apply some of the Article 14 principles in practice by a couple of case studies in the trafficking asylum support context. So that's the structure of the talk. If anyone has any questions as we go along, please feel free to put them in the chat, and we'll do our best to answer them as we go along. So first, just a brief summary of the book, in case it helps if you're looking into it. The aim of the book is to give public lawyers, claimant public lawyers in particular, all you need to know about discrimination in public law. So it aims to summarise the key principles in all of the 4 different areas that may arise. So Article 14, Equality Act, including the public sector equality duty, EU law, so far as it's retained, and also public equality law, although that's a very short chapter, not least because the Supreme Court, in its most recent consideration of the principle of public law equal treatment, said there isn't one, although it's a bit more complicated than that. So the book includes both an analysis of the key principles, but also looks at all of the specific areas where they can be applied, which Sue has just briefly mentioned earlier, she's mentioned some of them. And the aim is, if you have a case in a particular area, for example, you're looking at a Thlimenos discrimination case involving asylum support, then you can find both the general principles and also all of the cases in the particular areas that you're looking at. So that's the book. Then just a few key controversial issues that I can deal with in the remaining 10 minutes that I hope are of some interest. The first area that I struggle with is indirect discrimination. Under both Article 14 and also under the Equality Act, the test is pretty similar and will often be the same. You're looking at an ostensibly neutral measure that has a disproportionately prejudicial impact on a protected group, or that is, it puts a protected group at a particular disadvantage. Now, that sounds relatively simple to start with, but actually in practice, in applying it, it can be really complicated. For example, the idea of a particular disadvantage, how do you prove that? And just to pick off 3 particular examples as to the difficulties that might arise. One question is whether statistics or showing a particular disadvantage of your specific group are enough to show indirect discrimination. For example, ethnic minorities, in particular Black people, are treated violently by the police disproportionately as compared to white people. There's clear statistics to show that in whichever way you look at it, they're treated with violence in a disproportionate way. Is that sufficient to show indirect discrimination? Or do you have to go behind it and look into factors, well, in the individual case, was there a justification for it? Were they treated with violence because they were a threat in the individual case? A very useful case in this context is the leading Supreme Court case regarding Equality Act indirect discrimination, which is ESSEP against the Home Office. One of the cases of ESSEP concerned civil service promotion, and there was an exam for civil servants when they want to be promoted from one band to another and therefore obtain more money. They have to sit an exam, and statistics showed that there was a disproportionately prejudicial effect on ethnic minorities, in that a high proportion of white people would pass than ethnic minorities. And it was questioned up to the Supreme Court, is that enough to show prima facie indirect discrimination? Or do we have to look at other issues, such as, was there a reason that they didn't pass the exam? For example, did they not turn up? Or were they less prepared to do the exam? And the Supreme Court decided that you didn't need to look into those background issues. The statistical evidence to show a disproportionate treatment of the protected group was sufficient. And that should stand as a very useful case in a number of other contexts, for example, the police context. Of course, once you get to the second stage of the analysis, which is, has the police justified the indirect discrimination, then those sorts of issues would become relevant. So the issues like, was there a particular reason as to why they were treated with violence or otherwise? So that's one tricky issue. Another issue is, do the terms of the rule themselves have to cause the disadvantage, or can the manner in which they're applied do so? And a useful case on this is DH against the Czech Republic, which is a foundational Article 14 case. That involved Roma children in the Czech Republic. And there was evidence to show that a disproportionate number of Roma children are sent to what were called special schools than others, and evidence also to show that special schools were worse than other schools. And it was agreed between the parties that there was nothing inherent in the legislation which caused that. It was, if anything, the manner in which they were applied on the ground by individual officers which had that effect. And the Grand Chamber said that's enough. So you don't have to show the terms are inherently discriminatory in themselves. It's the way the system operates that can be indirectly discriminatory. Another issue about indirect discrimination is whether if there's an adverse impact on a group, whether the fact that a greater proportion of that group are from a protected characteristic than others is sufficient to show indirect discrimination. So, for example, a case SG, there was a cap or a reduction on welfare benefits, and a greater proportion of that group were women. And in that case, that was enough to show indirect discrimination. In some other cases, there's a pensions case called Delve, and a couple of other examples, it wasn't enough. But if you have that type of case where you're looking at a group that was disadvantaged and a greater proportion from your protected characteristic, then have a look at SG. I'm jumping over a couple of issues because time's pretty tight, but one key point about bringing public law discrimination claims is, from an early stage, it's really important to think through the discrimination test, make sure your case fits it, and make sure you have enough evidence for that to establish it. So with an indirect discrimination case, for example, you need to think really carefully about what is the provision, criterion or practice that you're looking at. Does it fall within the categories that the case law have said amount to PCPs? In an Article 14 case, what status are you looking at? So, for example, there was a recent case which Ollie was involved in, MOC, against the Secretary of State for Work and Pensions, which in the Court of Appeal decided that mental capacity wasn't a status. And that caused problems in proving indirect discrimination. And one thing that you can do is to choose two statuses. So if you're a bit concerned that one of them isn't going to work out, then choose two and get evidence to show that there was indirect discrimination impacting on both of them. Work out what the disadvantage was. You have to, in indirect discrimination cases, in the first place, look at the impact on the group as a whole. So make sure you have evidence to show disadvantage to the group as a whole. Another key issue in this sort of case, and one about which it's important to try and start thinking about at an early stage, is justification. SC in the Supreme Court last year decided that when looking at what discretionary area of judgment the government has when it comes to justification, one has to take a flexible approach, and you have to take into account all of the relevant, a whole range of common sense factors in deciding whether the state has a narrow margin of appreciation, in which case the court is ready to intervene, or a very broad one, in which case it isn't. So, for example, common sense factors include how sensitive the status is, how serious the impact is on the individuals, whether it involves a controversial economic or political issue rather than a legal issue, and the extent to which Parliament or the public authority addressed its mind to the discrimination in question. And it's a good idea to try and start thinking about what evidence you have about all of those factors at an early stage, and also to try and frame your case in a way which is helpful. So, for example, a British Medical Association case, which was about pensions in 2020, in that case, the claimant presented it as being a challenge to a rule which suspended a pension rather than a rule about whether a pension would be applied at all. And the court said, well, there's a lot of case law which says rules which determine whether or not pensions will be given are matters for Parliament, and so the courts take a hands-off approach to it. But this one's not about that. It's about whether pension will be suspended. And that's a legal issue. It's not really a political issue. Therefore, we're more willing to intervene. And so framing the case in that way was very important. The last issue that I hope to cover, and I'll just very briefly do this because of the time, is Familial discrimination. That is that the state is obliged to treat certain groups differently if their circumstances are significantly different, unless there's a justification for not doing so. Now, that's a relatively undeveloped area of law. It's been applied in a number of specific areas. For example, groups which have been found to be significantly different include victims of domestic violence, lone parents with children under the age of 2, victims of trafficking, which Shushin's going to talk about later, Windrush victims, Roma children, vulnerable groups, and groups defined according to sexuality. And although the principles aren't particularly clear at this stage, it's a good idea to have a look at those cases and think about whether they can be applied in a number of other contexts, because there's no, just because they haven't yet been applied in other contexts, there's no reason they can't be. Okay, so that's just a whistle stop. I was going to talk about a couple of other issues, but I realize my time is now out. So I hope if you'd like to look into these in any more detail, you'll have a look at this actually excellent book. And now I'll hand over to Louise.
Thanks very much, Adam. I wish you'd had time for the extra 2 points, because I was learning quite a lot just in that 10-minute slot. So thanks very much. And thanks for asking me to speak. I'm talking to the very loose title that I thought up of, Discrimination in Public Law, Why This Matters and What You Can Do About It, which is going to be a sort of 10 to 15 minute crash course in how I accidentally became a discrimination law expert, apparently, and how it's relevant to my practice now, and what I think is really, really important about bringing discrimination law claims within judicial review claims, and also what you can then do to also become discrimination law experts, possibly by accident, possibly more deliberately, by reading Adam's book and doing a few other things that I've got to suggest. So I'm the head of legal casework at Liberty now, and I lead on the disability rights litigation that we're doing there. And I'm also starting to look at cases around socioeconomic rights, which obviously raise a multitude of discrimination issues as well. But when I was thinking about the work we're doing and where discrimination law fits into the public law challenges that Liberty brings, I realised that it runs throughout almost everything we're doing. Our litigation around policing focuses almost entirely on race discrimination cases. We're also looking at cases against the police that include disability discrimination arguments and sex discrimination arguments too. We're looking at discrimination in the context of mass surveillance, because of course the use of facial recognition technology is essentially discriminatory. We're also looking at it in the context of protest rights, because we've had more than one case where we can see that people's protest rights are affected by the way they are treated, depending on which groups they're from or which groups they're campaigning with and on behalf of. We're also looking at discrimination in the context of voter ID, which is being introduced in the elections bill later this year. So it's a key part of our work, which makes me really delighted that Adam's written this book for us. I really, really wish I'd had this 10, if not 20 years ago. I drifted into doing discrimination law because I was doing a lot of work with disabled people's organisations and also women's organisations, mainly about funding cuts or cuts to services that they were very reliant on. And I ran a number of public sector equality duties cases in the sort of late noughties and early 2010s, when it was still referred to as the race equality duty or the gender equality duty or the disability equality duty, before it became the PSED. And that's when I was still at PLP and then Pearce Glynn and Dighton Pearce Glynn. And it was running those cases and working with those groups that I realised I was sort of tinkering around the edges of discrimination law, but there were these massive gaps in my knowledge, and that I wasn't really using the Equality Act as much as I could, and that I really needed to up my game, because I felt that even the successful public sector equality duty cases were of limited value, although most of the ones that we won or that settled, we did get a new decision that was much better than the old decision. But we won a big case in the Court of Appeal where there had been a breach of the duty, but when the government took the decision again, they reached the same conclusion and they closed the Independent Living Fund. And that was the kind of case where I started thinking, well, due regard is all very good, but it's not really enough. Are we actually missing a trick in not running some private law discrimination arguments or making better use of Article 14 grounds in challenges that we were bringing? And I think that what I spotted as I started to try and raise these arguments more frequently in pre-action correspondence was that we sometimes got better engagement from some of the public authorities. Maybe they'd all secretly been getting advice from employment lawyers who did know about discrimination laws, so they were more inclined to settle this kind of case. Or maybe it just resonated more with what they were getting wrong. I don't know, but we felt that we were getting a bit more leverage, a bit more purchase on some of these issues that we were raising. So that's really how I got to this place of trying to use discrimination law more in public law. But I think the reason I think it really matters and is so important is because public authorities just keep getting it wrong. They keep discriminating against people. And I know everyone here will know the reasons for this, but to state the obvious, public authorities have too much power. They are invariably run by white, non-disabled, middle-aged people who are often predominantly heterosexual cis men. So they don't have the experience, the insights, everything else that helps them understand and make good non-discriminatory decisions. I think discrimination public law is really important because it's a powerful tool to challenge that structural and institutional discrimination. There's only so far you can get with the public sector equality duty, and although Adam's book covers that, there's so much more to discrimination law than that that's really, really important. And whether it's, you know, trying to keep the Independent Living Fund open, or keep funding in place for a schools project for Roma children, or get a woman novelist on a banknote, or get civil partnerships for different sex couples. There's lots of ways and lots of cases that we all should be using discrimination law in. I also think it's really important because it's a crucial way to get the court to see things differently and from the client's perspective about, you know, why they need specialist domestic violence support services, about why buildings, public buildings, need to be accessible to everybody, why housing should be accessible to everybody, and to get the court to understand why predictive policing means more young Black men will get stopped and searched, not fewer. And also, I think it provides much more opportunity in some of the cases I've done within a judicial review to allow the client to share their experiences, which I've often seen as fundamental to the success of the case and enables them to get their voice heard, really. It's not just focusing on technical legal arguments about why the decision-making process went wrong, but what was the adverse impact on them? Why was this so disastrous? And also because we're only going to get the change we all want to see if we can call out the discrimination and we actually build it into the legal cases that we're bringing. So turning briefly to what everyone on this call can do about it, obviously point number one is buy and read Adam's book. I was looking at the index and genuinely not knowing whether to smile or cry at the fact that this was the book I seriously wish I'd had over the last couple of decades, because it's so, the index itself is so brilliantly set out. As Sue said at the start, it's everything you need in one place. And then you can kind of like, I'm quite, God, this sounds so geeky, but I'm quite looking forward to switching between the, you know, Equality Act stuff and Article 14 and all that small chapter on public law equal treatment. I seriously have never been so excited about the publication of a book. But anyway, moving on. I think what's a really, really good way to practice in an area where you feel you're sort of stretching out of your comfort zone is to think about every case through a discrimination lens, even if it's not really obvious. Just think about it. Talk to your clients about it, obviously, but also the groups that are supporting them. Talk to your colleagues, talk to counsel. Test out the arguments. You might not run them this time round, but it helps you work out what you might run next time. And that's definitely how I got into discrimination law and really built up my practice, was trying again and again to sort of test the waters. Maybe you put it in a letter before claim, maybe it doesn't work this time. Then you have another discussion with the group, particularly the disabled people I've worked with. I'm not a disabled person. My understanding of disability discrimination is very, very limited, but hearing their descriptions, their explanations of what it was like to, for example, not be able to get into the Royal Courts of Justice, even when it was a hearing about disability discrimination, that really changed the way I framed arguments in a future case. So, you know, talk to your clients. That's the whole point of the exercise, is to represent what's happening to them. I'd also suggest thinking about intersectionality, which is really this incredibly important concept of when you have been discriminated against on the basis of more than one protected characteristic, which is not truly provided for in the Equality Act 2010, which seems completely bizarre to me. So, for example, the Muslim woman MP who said she'd been discriminated against on those combined characteristics would not necessarily, other than in an Article 14 other status type way, she wouldn't be able to use discrimination law protection for that specific type of discrimination. And I think we should all be thinking about how to progress that, because that is the discrimination that's particularly problematic for groups who are facing the worst discrimination. And also, two sort of practical tips, I would say join the Discrimination Law Association. Although it tends to predominantly focus on employment law, they have great briefings that cover lots of areas of law, lots of different cases, different protected characteristics. They run great conferences every year on different themes. There's always really good breakout sessions and very, very good, interesting speakers and panels, and they have practitioner group meetings as well. And I have learned a lot by sitting through some sessions I didn't really understand about a lot of employment law that was really technical, and then the penny has dropped about a particular indirect discrimination point, a bit like Adam was talking about earlier. And I think that's a really good way to learn. And then my last point is PLP runs conferences that are basically discrimination law for public lawyers, and they're another really good way to expand your learning, to get your head around some of these concepts, even if you're feeling sort of out of your comfort zone, to bring them because you see yourself as a traditional public law specialist. So I think we can all take these steps to make discrimination an intrinsic part of all our public law work. And I just want to thank Adam and Ollie and LAG again for producing the book I wish I'd had 20 years ago. Thank you very much.
Sign me up, Louise. That sounds great. I am talking about what might sound a potentially dry topic, which is retained EU law. I'm not going to try and explain what it is in the next 11, 12 minutes, but give you a taster about what the concepts are and why they might add something to your public law practice. So next slide, please. And this is probably the highlight of my presentation, and it's all downhill from here. So what is retained EU law? It's a snapshot frozen in time at the end of 2020. Well, actually 1 hour before the end of 2020, so the last photo is inaccurate. But that is what retained EU law is. Next slide, please. So it introduces an entire new language around EU law, which we're all going to have to get our heads around. And hopefully the chapter of the book that I wrote is a guide to navigating these principles. But what I want to say at the outset, it's not a list of all the retained EU equality law. It's the guiding principles for you to go and find out what is retained EU law, retained EU equality law. And I'm not going to go into any of this in any detail in the next 10 minutes, but as you'll see, these are entirely new concepts. EU-derived domestic legislation, well, that includes primary legislation, and I'm just going to speak to an example in a minute. Retained direct EU legislation, well, that is EU legislation that was directly effective, with some exceptions, notably directives. Then there's directly effective provisions of EU treaties, and there's a weird test for that, which we go through in the book. Then there's retained EU law, EU case law and general principles, which, yes, they're saved, but it's unclear to the extent that general principles are saved. It's said that general principles are only saved as an interpretive aid and can't form a right of action on the basis of them. But you can on the basis of retained EU case law, but general principles are in case law. So it's all a hot mess, I'm afraid, but hopefully this will help you navigate it. I just want to give a big flag that the charter is not retained, but the general principles that underlie the charter are retained for the reason I just said. I also want you to be aware of Section 8 of EUA, which is a power to retain EU law, and I'll speak to that a bit more in a minute. So next slide, please. So this is just one example. This is EU-derived domestic legislation, and I wanted to show you quite how knotty it is and why we can't come up with a definitive list of what retained EU law is. So it means I've highlighted the bits in red and in green to separate from red because it's a separate point and it's next to the red bit. The key parts of this, and it's just extraordinarily wide what comes within the meaning of EU-derived domestic legislation. Any enactment so far as, so it's possible that within an act, certainly within an act, potentially within a section of an act, part of it could be retained EU law and part of it could not be. That's going to be an absolute minefield, which is going to be litigated, hopefully by many people on this call. But look at subsection D, relating otherwise to the EU or the EEA. That is so extraordinarily broad. It's hard to think of what parts of the Equality Act aren't retained EU law, like the public sector equality duty, but there are some other parts, but it's going to be a lot of it. And notice, passed or made or operating for a purpose. Well, operating for a purpose could very clearly mean someone's just put my profile in the chat, thank you very much. Operating for a purpose could mean a piece of legislation that came in yonks before the Equality Act, like many of the race provisions. But when the EU law that came in that required something like those race provisions to be put in place, those old provisions were operating for a purpose of EU law. So actually, huge chunks of the Equality Act, even the predecessor legislation predated the EU law obligation, retained EU law. So this is huge, potentially. Next slide, please. So what's the consequence of something being retained EU law? The big one I want to flag is the supremacy principle. And spoiler alert, it's also unclear how that operates. So we're going to be litigating and finding out in the years coming exactly how this all fits together. And there's no doubt going to be a huge rewrite in the next edition of this book. Briefly, interpretive obligations are quite important because if something's retained EU law, the Marr-Leasing principle of consistent interpretation applies. And you also have to interpret with this corpus of retained EU law that existed at midnight 2020. Remedies, you can get quite useful remedies, including disapplication potentially, and vulnerability to amendment. And this is the health warning that we should all be vigilant for. So next slide, please. So the supremacy principle is one that we're probably all familiar. It kind of does what it says on the tin. Next slide, please. So nobody really understands how it operates in the context of retained EU law. This is the House of Lords Constitution Committee. Now, as I just mentioned, retained EU law is potentially extremely vast. If the Equality Act is retained EU law, does the Equality Act now have supremacy? That would be absolutely mind-boggling if that is the case. But I don't think it probably will be the case, because I think the sensible approach, which is far from clear on the face of the Act, is probably going to be adopted by the court, which is the more traditional retained EU law. So those directives that get saved, where they include rights that have been recognised by the court, or other directly effective provisions that are retained through the operation of the Withdrawal Agreement Act. They are probably going to have the supremacy principle, but a piece of primary legislation that becomes retained EU law, probably not, because that would be a massive change to the EU, to the legal order. But we just don't know at this stage. And it's sort of like, let's all pay attention and let's see how this develops, and let's argue for it to develop in a way that we want it to develop. But it's entirely unclear at this stage. It's all very much a nebulous thing. Hopefully, as I say, the book gives you some sort of tools to navigate this, but I'm sorry, it's not going to give you all the answers. Next slide, please. And very briefly, I think I've already mentioned this, there's an interpretive obligation, and EU court decisions that predate 2020 withdrawal going to be very important. But you can have regard to decisions after that too, but less so. General principles distilled in time at the end of 2020, important for interpretation. Next slide, please. If equality law is retained, then it is vulnerable. And so I think that I would like to give a warning about how we argue whether, to what extent, the Equality Act is retained EU law. So it might be very nice to argue it's retained EU law if it had supremacy, but if we're unlikely to establish it's got supremacy, we don't really want it being treated as retained EU law, because Section 8 of EUA, the European Union Withdrawal Act, confers extremely broad powers, which only have limited safeguards. For example, the Human Rights Act is protected, that include so-called Henry VIII provisions, which allow amendment of primary legislation by statutory instrument of anything that is retained EU law. So you could have substantial attacks on retained EU law with very little parliamentary scrutiny. Now, because that's done by secondary legislation, that's amenable to judicial review. But it's something we all need to be absolutely vigilant for, because we all know that there's a move to governance by secondary legislation rather than having detailed acts of parliament. And I really recommend the Hansard Society Statutory Instrument Tracker, which you can sign up to. And it's a really neat way of navigating by subject matter, and it gives you alerts of interesting new statutory instruments that are coming in as they're being made and laid before Parliament. So I think that might be my last slide. Correct me if I'm wrong. Yes, great. And thank you very much for your time.
I'm next. So I have the graveyard slot and I'll try to be quick. I don't have fancy cartoons to kick everyone off and make sure that everyone's listening, because I just don't have that kind of know-how in my IT abilities. But can I just echo what Louise has said about how amazing this book is? I mean, it really does distill what seems to be very complex concepts in discrimination law, which have been the subject of hundreds of paragraphs in just one judgment, two judgments alone, but made it really easily accessible and understandable and easy to apply in practice. I've been asked to look at discrimination in the context of the area of trafficking and asylum support. And I know this sounds like a very, very niche area, but some of the recent cases, I think, do provide useful illustrations of how the discrimination principle under Article 14 can work in practice, perhaps much more so than the acrobatic wrangling that often happens in discrimination cases concerning social security and welfare reform. Next slide, please. So there are two cases that I want to focus on. One is called MD and the Secretary of State for Home Department, and it really kind of draws out the question of how wide is the margin of appreciation to be afforded to the state. And the second case is IJ Kosovo, which looks interestingly not at individual discrimination on the basis of a rule, but where policies give rise to risks of discrimination and them being held unlawful as a result of that. Next slide, please. So MD, I've set out the facts here on the slide, but in brief, it's two single mothers with dependent children, and they were both victims of trafficking and asylum seekers. Basically, the Secretary of State runs a scheme that allows victims of trafficking to have financial support to meet both their essential living needs, so like destitution-based needs, and also needs relating to the social, psychological, and physical recovery. At the time of this claim, victims who were asylum seekers got asylum support to meet essential living needs and a top-up for their recovery needs. People in mainstream support, so victims who are British or have settled status and in receipt of universal credit, they would have their essential living needs met that way, and they will also get a top up for their recovery needs. Where the difference arises is where the victim on mainstream support also got some money additionally to enable them to purchase childcare so that they can attend appointments, legal, medical, counselling, which children should not or may not be able to attend. And victims who are asylum seekers didn't get the same thing. Next slide, please. So the claimants brought a discrimination claim on two bases. And just to echo what Adam was talking about earlier, is picking two different statuses running the same argument, the same framework under two different ways of putting the discrimination claim. And the first one was discrimination that is direct. So their rights under Article 14 read with Article 4 and A1P1 were breached because they were treated differently from a group of another group of victims of trafficking, but where they really actually are relevantly similar groups. The second way is the indirect discrimination. So they are asylum-seeking victims of trafficking who are lone parents who have been disproportionately affected and prejudiced by having no money to purchase childcare, and therefore impacting on their ability to actually recover themselves. And the defendant's case, which is quite interesting, is the defendant admits a difference of treatment as between asylum-seeking and mainstream supported victims, but says, oh, well, that was actually just an inadvertent error and not deliberate. They made a mistake. And what they had meant to do was actually make sure that Universal Credit deducted the amount of money that they received from for childcare and trafficking support terms, but for some reason they didn't do it. And in terms of indirect discrimination, they say there's no indirect discrimination because your comparator is a male victim of trafficking who is also a lone parent, who is also asylum seeker. And in any event, whatever the case may be about the difference of treatment, it doesn't impel the court to impose immediate solutions to complex problems. And they quote the margin of appreciation that the state has in socioeconomic policies. And in any event, the Secretary of State now realizes this inadvertent error. And so it's going to try and fix it in a way that would be fair to asylum-seeking victims. Read, we will remove the support for mainstream supported victims. So in relation to the court's analysis, if I could do the next slide, please. So in this case, unlike a lot of Social Security cases, the argument really, the battleground really primarily was on justification. Unlike in a lot of Social Security cases, the points are taken on every single ground: status, ambit, difference of treatment, and justification. And so in some sense, this case provides some simplicity in understanding the scope and breadth of the margin of appreciation. So in here, you've got a status which is other status, but also a status as women. So asylum-seeking victims of trafficking or lone parents, the majority of whom are women. And then there is an admitted difference of treatment in relation to direct discrimination. And in relation to indirect discrimination, the court interestingly rejected the comparator to male lone parents, and rightly so, because the evidence before the court was that lone parent victims of trafficking are predominantly women. So the core status here arising in the context of indirect discrimination is actually women as a group that should be protected. And that's because not having additional support in this context has a disproportionate effect on lone parents who don't have a co-parent to help them with childcare whilst they attend counselling or other kind of recovery needs issues, or they have to spend their own money to pay for childcare, or actually just forego the benefit of going to these appointments. Next slide, please. And before I look at the court's analysis on justification, all I would flag is there was a faint dispute over ambit, with the Secretary of State arguing that the UK's anti-trafficking obligations don't actually require financial support to be given to victims of trafficking to purchase childcare. But I say faint dispute because the Secretary of State also accepted that for whatever reason they decided that victims of trafficking with dependent children who are not asylum seekers should actually get this because this is part and parcel of their recovery needs. And that wasn't said to be inadvertent. What's interesting here is two arguments were run, one on the basis of Article 14 and one on the basis of irrationality. And those of you who remember more recently the cases of Johnson and the Secretary of State for Work and Pension, and another case following called Moore and the Secretary of State for Work and Pension, the court started to really think about Article 14 cases in the context of Social Security discrimination by looking at common law irrationality. And Johnson was indeed a case where ultimately the Court of Appeal decided the common law argument on irrationality and discrimination from an equal treatment point of view on that basis, and decided not to go on to decide Article 14. In Moore, the judge really wanted to look at the case as an irrationality case, although it was insisted upon him that it needed to be looked at through the lens of Article 14, because it's about really discrimination between men and women in the context of receipt and deductions of universal credit. But the court had a tendency and desire to look at it from a Wednesbury rationality point of view. Here, however, in MD, what's interesting is that the court actually found that in this respect, the Secretary of State explanation that the differential treatment was likely to be a mistake was probably correct. Although the Secretary of State actually said to the court that they had no corporate memory whatsoever of how this policy came about, why it's there, why it is in statutory guidance even. But what the court said was the underlying policy judgment not to pay asylum-seeking victims of trafficking dependent child trafficking payments. It seems harsh, but it's not irrational and not contrary to international obligations, because there's no actual duty to cover these costs. So on irrationality, the case was not successful. But on justification, what the court really was unimpressed by is the argument that the court should readily defer to the state's margin of appreciation, just because the matters fall within the field of social and economic policy. And I think what the Secretary of State actually said was, let me just find what the Secretary of State actually said was that the ECHR didn't require administrative perfection. And so it's well within the margin of appreciation to make mistakes like this and be forgiven for that. And the judge really took umbrage to that, because what he found was the issue here in terms of the difference of treatment is not arising from the exercise of the judgment, but from the Secretary of State's failure to implement its judgment. So its judgment call is, well, no one should really get child dependent support, but I failed to implement it as against people who have mainstream support instead of asylum support. And one of my favorite parts of this judgment is the judge saying the margin of appreciation protects the making of a judgment, but not incompetence in executing a judgment. And the margin of error is not the same as a license to err. Next slide, please. So, oh, sorry, I moved on a little bit quicker. Before I move on to the next case, I mean, but essentially, the Secretary of State said, well, I've made a mistake, please pardon me, don't just indulge me and don't intervene. But the court actually took an approach of actually looking at the severity of the issue impacting those affected. And this is where you think about evidence gathering that Adam was talking about earlier, and accepted that the impact of the error, whatever the reason for the error, it was significant for those who are asylum-seeking victims of trafficking. And the purpose of the support is to help protect them and to help them recover. And so to deny them because of some mistake, that is something that needed to be looked at and taken seriously. So in that sense, in terms of the response to the Secretary of State saying, oh, well, we'll be fixing this at some point in time, although we can't tell you how we're going to fix the system, but we're thinking about how to fix the system. The court distinguished this from cases like Steinfeld and Harrison, which concern sort of changing societal attitudes about civil partnership with opposite sex couples or humanist marriages being recognized, and said, you know, I know in those cases there's talk about changes and changing mood and the law needing to keep up with that. This is sort of not one of those societal change type cases. This is a difference of treatment caused by incompetence and a mistake. And so therefore those line of cases and analysis in those cases on justification wouldn't apply comfortably in this context. It's interesting in remedy terms. So in this case, the financial loss of was kind of awarded from a back payments point of view, and there was also a modest award of non-financial loss to compensate for distress. But I understand from the lawyers involved that the Secretary of State has appealed this case, And one of the arguments is that the non-pecuniary loss, there had to be evidence showing that there was a direct connection between the distress caused and the discrimination, which is quite interesting because obviously in most ECHR cases, the approach of the Strasbourg court is to assume where discrimination arises or where there's a breach of Article 8. Oftentimes they assume that there is some distress if they meet the threshold of just satisfaction. So it'll be interesting to see what the Court of Appeal in the end says about that. In terms of IJ Kosovo, I'll speed through this because my time is running out. But this is another victim of trafficking with a pending asylum claim when the claim was brought. And basically, she was asking for permission to work because her asylum claim was outstanding for a year or more. But the rules, the immigration rule for permission to work for asylum seekers is very strict. You can only get permission to work on one of the shortage occupation lists, which is essentially very specialized work, like a doctor, certain nurses, certain areas of therapy, some teachers in certain subjects, IT professionals, engineers, chefs of a certain level of expertise. So it's really hard to actually get permission to work in these types of jobs. And the immigration rule itself is applied in a bright line way. So it doesn't on the face of it allow for any discretion to depart from the shortage occupation list. What the claimant asked for is a discretion to be exercised outside the immigration rules to allow her to take up employment as a cleaner. And what she said is, well, I'm a victim of trafficking and here's some medical evidence because it actually helps me with my recovery, my psychological and physical recovery, because I'm working and it will help me integrate and help me with my trauma. And she said that it was consistent with the obligation that the Secretary of State had under Article 4 of the ECHR and international anti-trafficking obligations, and that she should be treated in any event differently from asylum seekers generally. So the defendant, the Secretary of State, agreed that there is a discretion that can be exercised in principle outside the immigration rules in relation to a victim of trafficking. Although she didn't accept that there was a positive obligation to allow unfettered access to the labour market. In the light of that acceptance, the claimant also attacked the policy guidance issued by the Secretary of State on permission to work for asylum seekers, which didn't say anything about this potential available discretion outside the rules that may be exercisable. And what the claimant said is that is a serious omission and makes the guidance misleading because it creates a risk of unlawful decisions being made in a significant number of cases. She then also argued that the entire framework, the rule, the guidance, and the decision to refuse her permission to work was a breach of Article 14, read with 4 and 8, because it failed to treat people like her, asylum-seeking victims, differently to asylum seekers more generally. Next slide, please, sorry. So those are the grounds. Next slide, please. Next slide, please. Yeah, thank you, great. So the court's analysis, oh, sorry, Ray, can you go back one slide? Thank you. So on ground 1, the individual challenge, the court didn't find for the claimant, but the court didn't find for the claimant in 2 ways. One is that there wasn't a duty under the international trafficking obligations to grant unfettered access to the job market for victims of trafficking. So it's not per se unlawful not to allow her to have authority to work as a cleaner. Secondly, the Secretary of State in her particular case did exercise discretion and did take account of her circumstances, including the medical evidence, but the outcome was not in her favor. That did not make the case unlawful. There wasn't an irrationality argument run, but it was just failure to consider relevant material factors. And the court found that those factors were considered. As for ground 2, which is to do with the policy, because the Secretary of State accepted that the discretion can be exercised outside the rules in relation to asylum seeking bots, but it wasn't stated anywhere in the policy, the court did accept that the guidance was misleading because the caseworkers here relied on this guidance to make all the decisions pertaining to permission to work. And if they don't know and they weren't told that there is a discretion that could be applied in the case of victims of trafficking, how are they meant to know that they can do that? Next slide. So in relation to the guidance, it was unlawful, not on discrimination grounds, but it was just unlawful for being an unlawful policy leading to a risk of unlawful decisions. I'll come back to how that works in the context of the new case, the recent cases in the Supreme Court in A and BF, because this is a pre-A and BF case. On ground 3, which is discrimination, the way the court broke it down was to first look at the immigration rule and whether or not the rule itself was discriminatory. This wasn't pressed by the claimant. The claimant didn't dispute that the rule was capable and did operate in a proportionate way by applying a residual discretion outside the rule. So in that sense, it was similar to the way that the right to rent cases were dealt with. Is the guidance discriminatory? Well, the court already found that the lack of reference to residual discretion created a real risk of unlawful decision making. And in that sense, it's also said to be discriminatory because it then failed to identify ways in which asylum-seeking victims of trafficking can and should be treated differently to asylum seekers generally. And that omission is misleading, and the omission creates risks of unlawful discrimination against victims of trafficking who are asylum seekers. But in the individual case, it failed on the basis that the discretion was applied to her and her circumstances were considered, although the outcome was unfavorable. Now, this case was determined, as I said, pre the case of A in the Secretary of State and BF Eritrea by the Supreme Court, which obviously set down some quite stringent guidelines on policy challenges. But I think that even applying the Supreme Court's dicta here, you still have the right outcome. And I think I might have said that in my next slide. Can't remember now. Ray, can you turn to the next slide? Hope there's another slide. Yes, comments. Because if you look at what the Supreme Court said at paragraph 46 of A, there's 3 ways in which policy may be found to be unlawful because it either because of what it says or what it omits to say, where they make and you can see those 3 types. And really, I think this, when you look at the way that the cases are analysed by the judge, it falls within the last category where the authority decides to issue policy, doesn't have to, but it decided to issue policy, and it failed to set out a full account of the legal position by specific misstatement or omission, i.e. not saying that there is a specific discretion outside the rules exercisable in relation to victims of trafficking. It presents an overall misleading picture of the true legal position and creates an unlawful decision-making in a significant number of cases. You don't really need to have the statistics to show that because of the omission in this context. So I think even applying BF and A, the conclusion IJ Kosovo is probably the right one. And what's interesting here is that although there wasn't individual discrimination found, the policy was found to have a risk of unlawful discrimination, which I couldn't find a lot of other cases where it looked at that particular issue in that context, outside the sort of Article 3 context. So that sort of is 2 case studies looking at 2 different aspects of Article 14 discrimination and how it's applied in the context of public law. Thank you.
Okay, thanks very much, everyone. It's 5 o'clock, and so we'll leave everything there. But thanks again for everyone for speaking, and for Lag and Ray at Delta Street for organising.